Hello, this is Bay McFarland with Mary's Advocates Upholding Marriage, and I'm getting back to my viewers about whatever happened with our petition to the bishops. We collected signatures months ago and mailed letters to dozens of archbishops and all the bishops on the Marriage and Family Committee at the United States Conference of Catholic Bishops. And we were asking them to drop what we called their divorce mandate. In virtually every diocese, before a diocesan tribunal of judges will accept a petition from someone who's questioning whether their marriage is invalid, the tribunal requires the person to already have a state government civil divorce. And we were concerned that this doesn't make any sense. Divorce is a grave offense nature. It's immoral. I'll show you the petition on our website. So you can find this petition and you can read the language that we mailed to these dozens of bishops. And we cited things, the Bible, Malachi 2:16, for I hate divorce, says the Lord. Leo the 13th in 1880, who wrote our canon, he cautions, let no one then be deceived by the distinction which some civil jurists have so strongly insisted upon, that is the government judges or the lawyers in the government. They make a distinction by virtue of which they sever the matrimonial contract from the sacrament with the intent to hand over the contract to the power and the will of the rulers of the state, while reserving the question concerning the sacrament to the church. In other words, Pope Leo the 13th is publicizing what Mary's Advocates has been publicizing for over a decade, is that there's a difference between state power over marriage, government power over marriage, and this church was never supposed to separate our marriages such that we say, the sacramentality, whether it's valid or not, we'll let the church think about it, but we'll let the government, the state, decide cases of separation of spouses. And really, a divorce is just a separation of spouses where the government roles determine parties' obligations. So we mailed this petition off to dozens of bishops, but I never got back to you about the responses. We only got 3 responses, and 2 of them I think are very notable. So one of them came from the Bishop Cordileone and Bishop Paprocki. So the Committee on Laity, Marriage, Family, and Youth at the USCCB, there's Bishop Cordileone and Bishop Paprocki are both on that committee. But the interesting thing is they're also both on the Committee for Canonical Affairs. And Bishop Paprocki, who's in San Francisco, I'm sorry, I misspoke. Bishop Paprocki, who's in the Diocese of Springfield, Illinois, is the chairman of this committee. I want to start, though, sharing with you about the response that we got from, I want to go with Cordileone first. So Bishop Cordileone he's the Archbishop, is in San Francisco, and he got his canon law degree in 1985. He was sent to Rome, and he got his doctorate. And for a time in 1995, he served as an assistant at the Supreme Tribunal of the Apostolic Signatura. That's where Cardinal Raymond Burke used to be in charge. After he served like 7-ish years, he no longer is in charge. He's now only a judge. So what Archbishop Cordileone wrote us back was he's responding to our letter. And he appreciates our concern for civil divorce being required for parties who challenge the validity of their marriage. And he draws my attention, or our attention, to canon 1675, which says the tribunal judges, before he accepts a case that is a case for someone challenging whether their marriage is valid, the judge must be informed that the marriage has irreparably failed, such that conjugal living cannot be restored. This canon was actually dumbed down with Pope Francis's change in the canon law. But nonetheless, this is what it says now. The tribunal judge has to be informed whether or not the marriage has irreparably failed before he even starts investigating a case where someone challenges the validity of their marriage. But then he goes on to say, the civil divorce decree is not full proof that a marriage has irreparably failed. Yet, in point of fact, almost all the parties who challenge the validity of their marriage are already in possession of a civil divorce decree. Indeed, many find themselves cohabiting with another person with whom they have attempted marriage in the civil forum. And I've heard from other people that many annulment petitioners were not even, many annulment petitioners are in situations where it's a Catholic who entered in the civil court marriage with a non-Catholic who is civilly married. So the marriage, I'm making this too confusing. A lot of the cases brought to tribunal where they're questioning the validity of the marriage being challenged never occurred in a Catholic church. That's what I'm trying to say. But listen to this. If the petitioner has a civil divorce decree, we ask him or her to submit a copy. If the judge, however, has full proof of that irreparability without such a divorce decree, the judge may accept the case. So, in the Archdiocese of San Francisco, his tribunal does not require a civil divorce decree before they look into an annulment petition. They only are looking at whether the marriage appears as best as they can know to be irreparably failed. So like, that's cool. And then he goes on to say, he thanks us for our letter. And as a sign of solidarity with your concern, I have taken the opportunity to share with the staff of my tribunal a copy of his letter. And I assure you, I work closely with other departments. So he's sharing with his tribunal his statement as Archbishop of San Francisco. And he's also on the committee at the USCCB of canon the canon law committee. And he's also on the marriage committee. He's saying that a tribunal judge only needs proof, as best as they can discern, that the marriage irreparably failed, but without a divorce decree. They could look at an annulment case. So that's one. I thought, well, that's encouraging. I wonder if they talk among themselves. Now, the other one we got back was from Bishop Paprocki. Now, Bishop Paprocki is in the Diocese of Springfield, Illinois. Notably, he is the chairman of the Canonical Affairs Committee members. And his letter was different. So he's responding to our letter. And he points out, in response to your letter asking me to begin taking appropriate steps to repeal what you call the divorce mandate, I respectfully decline to do so. No diocese is mandating anyone to get a divorce. Well, you might not find that on any, I don't know why he's saying that actually, because if I'm questioning the validity of my marriage and I'm in a marriage where I'm unhappy and I go to my priest and say, I don't like my husband. And then the priest, well, I say other things like, oh, I'm so unhappy. I'm miserable. He's so boring. I want to go have my me time. Well, that's not what you say to the priest. You say other things. You might bring some box of Kleenex and start crying. I got to step back. I recognize there are real reasons for separation of spouses. I am talking about the woman who goes to a no-fault divorce court, but the last conversation she had with the priest that the husband knows about, and the priest even spoke to the husband thereafter. So I'm hearing the husband who's telling me, this is what the priest relayed. The woman went to the husband and tells the priest how unhappy she is. And the priest says, well, you could apply for an annulment, but you have to have your divorce first. Is that a requirement? Is that a mandate to get a divorce? Well, it's a mandate to get a divorce if you want to challenge the validity of your marriage at a tribunal, isn't it? For a lot of diocesan, the annulment forms that I've seen on their websites where you can download an application for an annulment, or you can download a preliminary questionnaire about moving towards making a petition for annulment, they will require that you have your civil divorce first. But nonetheless, Bishop Paprocki does say no diocese is mandating anyone to get a divorce. While a Catholic tribunal in virtually all the dioceses will not open a canonical process to determine the validity of a marriage if a couple is still civilly married, this is not the same thing as requiring them to get a divorce. Okay. The Catholic Church does not want to see people get divorced. Okay. Now here's the one that just keep listening. The approach you suggest, which is we're suggesting, hey, if someone questions the validity of their marriage, let them have a determination while they're still in the state of civil marriage. The approach that you suggest, however, could result in the anomalous situation of separated couples having their marriages declared canonically invalid while they are still married civilly. Doing so could also expose dioceses, tribunal personnel, and parish clergy to potential lawsuits in those states that recognize a cause of action known as alienation of affection, which allows someone who is currently or formerly married to sue a third party for interfering with the marital relationship. Well, I mean, no one's going to debate whether or not it's an anomalous situation. Where did that language go? Okay. It could result, if you're miserable in your marriage and you have reason to believe your marriage is invalid, like say your wife is out having an affair with someone in your wedding party, you've been married for a year, and you're challenging her as like, hey, won't you stick to our marriage promises? And she's like, you know, when I got married, I always knew I could get divorced if I wasn't happy. Well, if that's what she's saying, sounds like maybe she lied about permanence when she got married. So why can't you go to the church and have an investigation about an annulment while you're still civilly married? What's the state going to care? But anyways, I agree. It is an anomalous situation of separated couples having their marriage declared canonically invalid while they are still married civilly. But I ask the other side, what about the anomalous situation of those who are married in the church and civilly divorced, especially those who are married in the church and civilly divorced when there was no morally legitimate reason for separation of spouses, like all these people who talk to me and Mary's advocates who are pleading with their spouses to work on someone to help working on reconciling their marriage. So they're civilly divorced, but they're Catholic marriage, and there's no reason for separation of spouses, or sure doesn't seem to look like one when one party is pleading, hey, we can work on this. I love you. Let's get the right kind of help. And the other party is like, I'm out of here. So the one thing I wanted to point to you too, the last screen I have open here is, what is alienation of affection? These lawsuits that he's afraid, that he's concerned about, or he's saying this is why they require a civil divorce, because we want to avoid these anomalous situations. Now, findlaw.com, you can look up everything under the sun about legal business. And I just am going to share with you what they have as alienation of affection. Can I sue my spouse's lover in any state? These only exist in a small number of states. So here they are, 6: Hawaii, Mississippi, New Mexico, North Carolina, South Dakota, and Utah. So in those states, the tribunals are afraid that if they were to investigate invalidity of the marriage without asking for a civil divorce first, someone's going to sue them for alienation of affection. Okay, well then what, I want to make sure I'm using the right language. Did he say alienation of affection? They could be exposed to lawsuits to sue a third party for interfering with the marital relationship. Okay, that's the language he uses. I'm using alienation of affection, which is parallel or related. So what are the situations? Well, one is you were in a valid marriage with your spouse. So when could someone sue? What can I sue for? If you live in one of those 6 states, you may be able to bring a civil action against someone who ruined your marriage. A tort is a legal wrong that a civil court can remedy. For you to sue for dependence on what happened, for you to sue depends on what happened. So they call home record torts is what have been commonly called in literature. So one is criminal. You can sue for this. You must prove the following elements. You were in a valid marriage with your spouse, and the party you were suing had sex with your spouse during your marriage. Okay, let's just try on an idea here. The woman lied about permanence. She married a rich guy, and she's now divorcing him, and he's pleading with her to reconcile. And she's having an affair with a younger guy. If that husband goes to the church and says, I would like to start an investigation of marriage annulment before we finish our divorce process, but the woman's already divorcing me anyway, because I want to know what's going on and I want to prevent scandal. He cannot, the abandoning, the woman who is going to be aggrieved that would be suing the church, according to this story, because obviously the husband's not going to sue the church because he's the one that's going to the church saying, hey, will you please investigate? But maybe the woman would. She's not going to be able to go to court and say, oh, civil forum, I want you to sue the Catholic Church. I got married in the Catholic Church. My husband, who I don't like anymore, who I want to divorce, is saying that he had sex with someone else during our marriage, and that person is our home wrecker. Well, the church didn't have sex with anybody. Okay, so that's one. I think it just doesn't make any sense. But another one, here's back to the language I was using, alienation of affection. You can bring a claim for alienation of affection. You don't need to show that anyone had sex with anyone. Instead, you generally need to show the following. It starts with you are in a valid marriage. So if a woman lied about something major, Well, we can debate whether or not that's a civilly valid marriage or a church valid marriage. Did I say that right? Yeah. But then there is love and affection in the marriage. Well, if the woman's the one that's dumping the husband, is she going to complain to the government? Oh no, the church is alienating my husband's affection against me. It's like, wait a minute, woman, didn't you already tell him you don't like him anymore and you're having an affair with a younger man and you're sick of being married to him? And you also told him that you didn't believe in the permanence of marriage. If that's what happened, okay, that doesn't exist. Then here's one: the defendant or this alleged aggrieved woman who might put the church in risk of being sued for alienation of affection. She could complain the defendant, that is the church, caused or contributed to the loss of love and affection. It's like, wait a minute, the only reason the husband is petitioning the church for a decree of invalidity is that the woman wants to dump him. And he wants to have his status clarified before he goes through the civil process, because it kind of hurts a lot to sign divorce papers where you agree to split everything when you don't agree to a divorce at all because it's being forced on you because of no-fault divorce. He wants to know his status. He'd be at ease, also would prevent scandal if when those two get divorced, everybody could know, well, she actually lied about permanence when she got married. She was open to divorce the day she got married, and her bridesmaids and maid of honor could say the same thing. And then your spouse's love or affection was in fact lost. Well, in this situation, the husband is still loving her and pleading with her to get together. That's one example I could think of. What's another common grounds for annulment? Psychological grounds, grave lack of discretion of judgment. So what I see is the petitioner themselves are the ones who want the annulment, and they go to the church and they're coached to complain that I just had a grave lack of discretion of judgment. I didn't know what I was doing when I got married. Well, this scenario isn't going to happen here. Well, I guess it could. So let's try that out. I'm a woman. I'm miserably married. I want to divorce my husband, but we got married in the Catholic Church. Okay. And I'm going to go to the church and say, hey, church, I'm petitioning for an annulment because I had a grave lack of discretion of judgment. I didn't know what I was doing. And I want to do that before I go to the church, before I go to the government to get my divorce. That woman is going to go to the government first, because in the government, she's going to get a no-fault divorce. And there's going to be no care that she didn't hold up to her marriage promises because she has some alleged grave lack of discretion of judgment. So it's never going to happen that woman who's dumping her husband, who's later going to come back and say, I just had a grave lack of discretion of judgment. I didn't know what I was doing and I wasn't really married. She's not going to sue the church. Okay, let's say she did have a grave lack of discretion of judgment. And let's say the husband wanted to stay married. If the church found that she had a grave lack of discretion of judgment, is the husband going to go and sue the church? And is he going to be able to make these complaints against the church? There is love and affection in the marriage. Well, the woman's dumping him. The defendant caused or contributed to the loss of affection. Well, the woman applied for the annulment on her own initiative because she wanted to dump him and she's claiming she had a grave lack of discretion of judgment. The love and affection was lost before that. And maybe it would be really helpful for the husband when he's going through his no-fault divorce to be able to say, well, my wife complained that she was psychologically, what's the words that Pope John Paul II uses in his speech to the Roman Rota? In order to get an annulment based on 1095, grave lack of discretion of judgment, someone has to have a serious psychopathology. Well, if the woman really had a serious psychopathology that made her so outside the norm that she couldn't understand with her intellect and will and choose freely marriage, openness to children, sexual fidelity, permanence, and she knows how she's going to do all those things. How are you going to have openness to children? How are you going to raise a kid's Catholic? If she knew all that stuff, well, actually, if she was incapable of knowing all that stuff, then that's relevant to the spouse's obligations towards each other and the children. The man was just a victim of a woman who presented herself as mentally stable when she was actually suffering a serious psychopathology that was so serious that it is knowable by an investigation of witnesses. So I would think that this is very, very relevant to the obligations of spouses towards each other and their children. So that's my take. And those are the two responses we received. The most notable takeaway is we have Bishop Cordileone, who's a canon lawyer, who studied in Rome. Oh, the funny thing is these guys both got their degrees in canon law. Do I still have the search on canon? Yeah. They tell us where he went. So he spent the next this is Okay. Bishop Cordileone, he got his canon law degree, Gregorian University, and he was sent to Rome in 1985. Meanwhile, Bishop Paprocki, in November of 85, he went, okay, in 87, he did postgraduate studies in canon law from the Pontifical Gregorian University, Rome. So one guy, Paprocki, went there in 87, and Cordileone went there in 85. So these two guys were in canon law school at the same time. One is saying, look, as long as the tribunal, as best as humanly possible, has observed, has proof that they're irreparably failed, the marriage has irreparably failed, they can start an investigation about annulment without a civil divorce decree. That's Cordileone. Paprocki, well, we'd have if we let them do an annulment case prior to a civil divorce, we'd have an anomalous situation, which I say is true, but there's a worse anomalous situation, which is all these people who were married in the Catholic Church running around with divorces with no investigation about anything. And he says if they were to do an annulment decree first, they would expose the diocese, tribunal personnel, and parish clergy to potential lawsuits for those people who can sue for alienation of affection. That's what I call it. So should we care that diocese personnel are potentially liable for something that I think the chances of them ever winning are near zero? Or should we care that all these innocent spouses are being run through the no-fault divorce mill where their children are being taken away and the kids are being forced to go back and forth between two households just because someone is miserable in their marriage and they're refusing to work on reconciling? Thanks for listening.